June 16, 2023. The courtroom settles as the judges take their seats and proceedings resume. The witness who appeared the previous day is back on the stand this time for the part everyone has been waiting for: cross-examination. What follows is not just routine questioning. It quickly turns into a tense back and forth filled with objections, interruptions, and moments where sharp logic meets legal pressure. Some exchanges feel almost surreal. Others reveal just how carefully every word matters. So let's walk through exactly what unfolded step by step. The moment the court resumed attention immediately shifted back to the witness who had appeared the previous day. He had already adopted his written statement earlier, but the cross-examination everyone expected never happened then. Now, with the judges seated and the courtroom settled again, it was finally time. The witness was called forward, reminded of the oath he had already taken, and confirmed his testimony. There was a quiet tension in the room, the kind that usually means things are about to get interesting. The counsel representing the Election Commission stood up to begin. He opened with a simple greeting. "Good morning." The witness replied calmly, returning the greeting in the same steady tone. Then the questioning began. "Can you tell the court where you were on Election Day?" the counsel asked. It sounded straightforward, but before the witness could fully respond, the lawyer abruptly interrupted and pressed him again, insisting that he answer the question properly. In a tone that raised a few eyebrows, he even suggested the witness had been taught to repeat certain lines, implying that the answer might be rehearsed. You could almost feel the shift in the room. The opposing counsel rose immediately, objecting to what he described as intimidation of the witness. The objection was firm and direct. According to him, the line of questioning had already crossed into improper territory. At that point, the presiding judge stepped in. The judge looked toward the Election Commission's lawyer and questioned the remark about the witness being coached. Had he been present when anyone supposedly instructed the witness? Why make that accusation at all? It was a clear warning that the court expected a professional tone. The lawyer quickly softened his posture and moved on. The questioning resumed and the lawyer tried to reframe the issue. He asked the witness about the analysis he had prepared about the report he produced and whether he had been paid to do it. The witness responded with the same calm composure that had marked the start of his testimony. He explained that he had been requested to prepare the report, yes, but no one had paid him for it. The lawyer seemed surprised. "So you did it as a patriotic Nigerian?" he asked. The witness didn't hesitate. "I am a patriotic Nigerian," he replied. And then he added something that made a few people in the room lean forward slightly. He said he also wanted to have material he could teach his students. There was no anger in his voice, no defensiveness, just quiet certainty. For a moment, the tension that had filled the room at the start of the questioning settled into something else, something more focused. The courtroom realized this wasn't going to be a simple exchange. It was going to be a careful battle of words. Once that first tension eased a little, the questioning moved into the heart of the witness's analysis, the election data itself. And this is where the exchange became more technical, but also strangely revealing, because the more the lawyer pushed, the more it became clear that everyone in court was not using the same language in the same way. The counsel turned to the witness's report and began asking about the materials he relied on. His primary source of data, the witness confirmed, was the IREV portal. Then the lawyer pointed to the witness statement where references had been made to forms EC8A and also to results uploaded on IREV, as if those two things should mean the same thing. The witness immediately slowed things down. "Not exactly," he said. That answer seemed to irritate counsel, who pressed him to explain what he meant by reports on the IREV portal. The witness clarified that what appeared there were copies of forms EC8A uploaded to the portal. Then came the obvious follow-up: are the EC8A forms and the documents on IREV the same thing? Again, the witness resisted giving a loose answer just to keep the exchange moving. "No," he said, "they are different." So what was the difference? At that point, he tried to make it visual. The actual form, EC8A, he explained, is one thing. What appears on IREV is a copy of that form after it has been uploaded. In other words, the portal shows an image or uploaded version of the document, not the physical form itself sitting somewhere in front of you. Counsel kept circling the point, asking whether the forms uploaded on the portal were the only things visible there. The witness answered carefully, and even that became a point of friction. When he said not really, the judge stepped in, clearly uncomfortable with an answer that sounded incomplete. But the witness explained why he had chosen those words. The question as framed did not call for a simple yes or no response. He was trying to be precise. That mattered. So the question was repeated. Were the uploaded EC8A forms the only things on IREV? This time, the witness expanded. No. There were also blurred images, and there were materials that did not relate directly to the particular analysis he had conducted. He mentioned, for example, that some Senate and House of Representatives results appeared under the presidential category. So from his point of view, the portal was not a perfectly neat self-explanatory dataset. It contained uploads, but not always in a way that answered every question cleanly. Then the lawyer shifted into what seemed like a broader challenge. In all the witness's review of the portal, had he seen anything there suggesting electronic collation? The witness paused over the wording. The lawyer, perhaps impatient, reminded him that he was a professor and should understand English clearly. But instead of reacting emotionally, the witness answered by drawing a distinction that turned out to be central. The portal itself is electronic, yes, but being electronic is not the same thing as electronically collating results. That distinction appeared to create some confusion in court. The judge stepped in again, trying to simplify the issue. The witness then made the point more directly. The portal can hold only what is entered into it. It stores what is uploaded. That does not automatically mean it is performing collation in the sense counsel seemed to suggest, and that was really the core of his explanation. To the witness, IREV functioned as a collection point, a place where copies of forms were uploaded and could be viewed. But he was not describing it as a system that independently computed or merged results on its own, merely because it existed online. That was why he resisted the wording of the questions. He was not denying that the portal was electronic. He was insisting that a storage or display function should not be confused with actual collation. By this stage, the courtroom exchange had become less about one witness answer and more about definitions. Counsel wanted clean admissions. The witness wanted precision. And the judge, caught in the middle, kept trying to keep both clarity and order in the room. After the long back and forth about the portal and the uploaded forms, the direction of the questioning slowly changed. The focus moved away from what the witness saw in the data and toward something else entirely: his expertise and the way he carried out the analysis. Counsel began pressing him on the documents referenced in his report. Earlier, the witness had mentioned thousands of blurred EC8A forms that appeared on the portal. The lawyer suggested that the analysis was supposed to rely specifically on agent forms from the Labor Party. The witness responded carefully, explaining that he did not rely only on those forms. His work involved more than a single document source. Before he could finish explaining, the lawyer interrupted him mid-sentence. The witness had begun referring to a specific portion of his written statement, but counsel cut him off sharply, saying he had not asked him to read anything aloud. He simply wanted confirmation that the witness had referenced the Labor Party agent's results. Yes, the witness replied calmly, he had. Then came another line of questioning. If those forms were part of the report, were they actually attached to the document submitted to the court? The witness answered directly. No, they were not attached. That answer opened the door to a new challenge. The lawyer leaned in and asked a question that sounded simple but clearly carried a larger implication. You are not an election expert, Professor, are you? The witness did not rush the answer. Instead, he paused and responded with a question of his own. It depends, he said, on what exactly is meant by an election expert. The room seemed to register the subtle pushback. The lawyer continued asking what the witness understood by the phrase. From there, counsel suggested that the witness had taken on a task that involved assessing compliance with electoral regulations and guidelines issued by the election body. According to the lawyer, someone making such conclusions would need a specific kind of expertise. The witness responded by referring to the rules themselves. If the Electoral Act and its guidelines say that results should be transmitted online, then determining whether that requirement was followed is something a person can evaluate, he explained. In his view, compliance could indeed be assessed by looking at what the data shows. The exchange moved quickly after that. Counsel asked when the witness completed the assignment he had been given. The answer came without hesitation. March 19th. Then the lawyer pulled out a document related to Rivers State and directed the witness to read details from it. The witness followed the instruction identifying the polling unit location listed on the page Emoji Memorial Hall. The judge leaned forward at that point and asked for the polling unit number. 002, the witness replied. The questioning continued with the figures shown on the document. Counsel pointed to the number of accredited voters and asked whether the figure was 40. Yes, the witness confirmed. Then came a quick calculation. If 40 voters were accredited and 40 votes were recorded, counsel suggested there would be no case of overvoting. Before the witness could even finish responding, the judge stepped in, urging counsel to move along and reminding him that time was running. The implication was clear. The arithmetic itself was straightforward. The witness simply confirmed the point. 40 plus 40 equals 80, he said with a faint smile. There was no overvoting. With that, the lawyer wrapped up his round of questioning. What had started as an attempt to challenge the witness's qualifications had instead turned into a brief but revealing moment, a courtroom discussion where legal argument collided with simple numbers. Just when it seemed that round of questioning had run its course, another counsel rose for cross-examination. The atmosphere shifted again. The earlier discussion about forms and polling unit figures gave way to a new line of inquiry, one focused on the scope of the witness's report. The lawyer began by pointing to something that stood out in the document the witness had submitted. According to him, the report seemed to focus on only 2 states, Benue and Rivers. The witness listened carefully and responded. At the time he was asked to present the report, those were the states he tendered, he explained. But the lawyer pressed the issue further. So you covered only 2 states? Again, the witness clarified. No, he said. The work he had done covered all the states. The reason 2 states appeared in the report presented at that moment was simply because those were the ones he was called upon to tender in court. The documents themselves, he added, spoke for themselves. The lawyer didn't seem satisfied. He asked the question again, this time in a sharper tone, suggesting that the witness should answer directly without adding commentary. The witness responded calmly that he had not intended to be rude. He was simply explaining the context of the report. The questioning continued. If he had tendered documents for Benue, the lawyer asked, had he also tendered documents for Rivers? Yes. The witness confirmed. Then came another question that drew attention across the courtroom. If Rivers was included, why had he not tendered documents for his own state? Before the witness could answer, the judge stepped in briefly, almost humorously questioning the logic behind that suggestion. The point seemed to be that the lawyer's framing of the question was not entirely clear, but the lawyer continued anyway, returning to the central theme. Apart from Rivers, which other states had the witness tendered evidence for, the witness seemed slightly amused by the way the questions were being asked, noting the tone with which they were delivered. Still, the judge eventually simplified the exchange. You tendered documents for 2 states, he said. Just answer that. The witness nodded. Yes, 2 states. That acknowledgement led directly to the next argument. If the report had been based on a limited set of data, the lawyer suggested, then it stood to reason that more data could potentially produce different conclusions. The witness did not dispute that possibility. Yes, he said. If more data had been available, the report might indeed have looked different. The analysis, he explained, had been conducted using the information that was available at the time. Then the questioning turned towards something else entirely when the witness had actually been engaged to carry out the work. The lawyer pointed to a section of the witness statement indicating that the request for analysis came on February 20th. But there was a small detail that immediately caught attention. February 20th was before the election itself. So the lawyer asked the obvious question. Was the witness being asked to conduct analysis of an election that had not yet taken place? The witness answered calmly. Yes, he said that was when the engagement was made. The implication hung in the air for a moment. The lawyer suggested that this meant the analysis had been planned in anticipation that the party requesting the report might lose the election and end up in court. The witness rejected that suggestion. No, he said simply. That was not the reason. the exchange highlighted a subtle tension that ran through the entire discussion. On one side was the idea that preparing analytical tools before an election might indicate expectations about legal disputes. On the other was the witness's explanation that the engagement itself did not revolve around litigation at all. For him, the work was simply analysis data numbers and methodology. The conclusions would depend on what the data eventually showed. And as the questioning continued, it was becoming clear that the real battle in the courtroom was not just about numbers. It was about how those numbers were interpreted when the analysis began, and what intentions people believed were behind it. The questioning then drifted into a space where law and mathematics began to collide. Another counsel stepped forward and tried a different angle, one that focused less on the story behind the report and more on the logic inside it. He began with a light remark about mathematics, admitting he wasn't particularly strong in the subject. With that, he passed the questioning to a colleague who seemed ready to challenge the witness from a more technical direction. The new line of questioning started with something that sounded almost philosophical. What exactly was the mathematical theory that allows someone to describe a document as blurred? The witness listened carefully before answering. "There is no such theory," he said plainly. The implication was clear. The observation about blurred documents wasn't some advanced mathematical claim. It was simply a factual description of what appeared on the portal. But the lawyer continued trying to narrow the discussion toward the witness's expertise. If there was no theory behind that description, could the witness really say that the report fell within his area of professional expertise? The witness responded with a touch of dry logic. If the question was about adding up polling unit results, he said then it raised an interesting point. How much numerical literacy does someone really need to perform basic addition? That remark subtly flipped the argument. If simple arithmetic is all that's required, then perhaps expert knowledge is unnecessary. But the witness did not fully accept that conclusion either. He explained that what appears simple on the surface can still involve careful interpretation once real election data is involved. The questioning then moved toward another issue that had already surfaced earlier in the day, the choice of Rivers and Benue states. Counsel suggested that selecting those two states as the basis for analysis looked like random sampling. If that was the case, he implied, then the report might simply be drawing conclusions from a sample rather than examining the full data set. The witness pushed back immediately. "No," he said. What he worked with was not sampling. He explained the difference clearly. Sampling is usually associated with forecasting or estimation methods used when complete data isn't available. In his analysis, however, he said he worked with exact results drawn directly from the data that had been obtained. That distinction mattered to him. The lawyer tried again, framing the issue slightly differently. If Rivers and Benue were selected randomly, wasn't that still a form of sampling? The witness shook his head. From his perspective, the randomness applied to the choice of states, not to the numbers themselves. The data he analyzed inside those states were the actual figures available, not estimated values. At that point, the conversation had turned into a quiet but unmistakable contest of reasoning. Counsel kept trying to frame the report as a statistical sample. The witness kept returning to the same point: the figures he worked with were exact data drawn from the records available to him. And in that moment, the courtroom exchange began to feel less like a legal interrogation and more like a debate between two very different ways of looking at numbers. As the questioning finally slowed, the witness stepped down and the atmosphere in the courtroom shifted again. One last attempt was made to tidy up parts of the testimony. The counsel who had originally called the witness stood up and tried to clarify a point that had come up during cross-examination, particularly around the use of other electoral forms beyond the EC8A documents mentioned earlier. But before he could fully develop the clarification, the presiding judge stepped in. From the court's perspective, the witness had already answered clearly enough. The judge signaled that there was no need to reopen the explanation. The counsel accepted the direction and sat down, bringing the witness's time on the stand to a close. What followed was a shift to testimony from media personnel. A staff member connected with television coverage took the stand, and for the most part, the questioning moved along without much drama. But one exchange briefly lightened the mood inside the courtroom. A lawyer asked the witness whether he was aware of a newspaper report claiming that the Electoral Commission had announced it would no longer electronically transmit election results after a particular interview. The question itself immediately drew reactions around the room. The witness replied simply that he was not aware of such a development. The lawyer then tried to rely on the newspaper article itself as proof referring to a specific edition and headline. But once again, the judge stepped in. The witness, the judge pointed out, had nothing to do with the newspaper. He neither wrote the article nor edited it. If the lawyer wanted the report to become part of the evidence, the proper step would be to formally present it to the court. With that brief exchange settled, the remaining testimony passed without major incident. As the day's proceedings wound down, the court announced that it would adjourn and reconvene on Monday, the 19th of June, 2023. And with that, another intense day inside the courtroom came to an end. Courtrooms can be strange places. One moment, the room is thick with tension, lawyers pressing every word, judges stepping in to keep things on track. The next moment, someone says something unexpected and the entire room breaks into quiet laughter. That's what made this session so fascinating to watch. The arguments are far from over, and the story is still unfolding. If you'd like to follow what happens next, stay with me and make sure you don't miss the next update.